Ladies and gentlemen, good things come to those who wait. So we have a lineup of superstars. I'm not talking about myself, of course. So I'm just going to stop talking and please enjoy our first speaker.
Well, thanks very much for inviting us to speak. So we're going to present a kind of an ongoing project that we've been working on. I say ongoing because I think both of us have been thinking about this in various ways for some time. Also, I suppose in terms of the work that we've been doing together in various projects, but also alone as well. Again, it's probably another kind of relatively provocative title, banning inaccuracy. Perhaps a better one might have been regulating inaccuracy, because I think it's probably more accurate as to what we're presenting. But I thought I would kind of start with the discussion, if I can move the slides, a little bit about, where my interest in the topic began, because I think it will kind of situate where we're going a little bit. So I started to think about accuracy mostly within the context of data protection law. There's a principle generally in data protection law that requires that personal data is kept up to date and corrected or deleted when relevant. And I was looking at this in the context of my PhD research that I'm kind of trying to transform now into a book through the lens of facial action coding, so examples of emotional AI. And I was looking at it in particular because these systems are, I suppose, widely reported as being wildly inaccurate. So there's a lot of like pseudoscience claims regarding them, and a lot of people saying that they should be banned or whatever else. So I was kind of looking at how data protection law could actually regulate technologies like this. And I was looking at data protection law in particular because there are certain accountability mechanisms inbuilt in data protection law that are quite robust. So there are requirements for data protection impact assessments or privacy impact assessments, depending on the jurisdiction you're in. There are also kind of data protection by design or by default requirements. And in jurisdictions such as the European Union, you have protections around automated individual decision-making and profiling. So I was kind of thinking, oh, well, there's some robust mechanisms here that could potentially play a role in regulating these types of technologies and dealing with the potential inaccuracies through these accountability mechanisms. And I was thinking about this through the lens of, okay, well, there are potentially two ways in which data protection law intersects with this type of example, both in terms of garbage in and garbage out. So I'm going to explain that with the help of a figure, a very simplified one. But by data garbage in, I mean everything on the left-hand side of it. So you could see potentially that there could be a role for data protection where personal data is processed, for instance, to train the model or, for instance, to query it. Yeah, but also then in terms of an output. So there may be inaccuracies in terms of the inferences that are drawn, and how would data protection requirements actually intersect with that? What I kind of found generally was that there were significant weaknesses with approaching this issue largely or solely, I suppose is a better way of putting it, through the lens of data protection law. The first is that I would say that generally there seems to be an assumption in data protection law that purposes are legitimate. It's more about risk mitigation. Now, we could have a discussion about whether there are substantive fairness requirements. I think there are to a certain extent, or whether it's mostly about process and the difference between practice and what's on the books. But I would say that data protection focuses more on the input side rather than the output side. And when you start to think about things like that, then you start wondering as to whether it's actually about conditions for lawful processing. Has the data subject consented and things like that? So you end up in a bit of a chicken and egg type situation as to where you localize the harm. So these types of things then made me question essentially whether some of these weaknesses, as I was calling them, are actually fundamental features of the framework and whether I was looking in the wrong place. And I suppose an important point within this is that inaccurate personal data are still considered, inaccurate data are still considered personal data. And there's good reason for this. If you look at for instance, if you sign up to a particular service, you give them your name, your telephone number, and your email address, and your home address, and you change some of those, that personal information about yourself. That doesn't mean that it ceases to be personal information. That's for good reason. So I started to think then a little bit, okay, well, what about the flaw? If there's a flaw in the methodology, and I think this is kind of getting to what Jeannie and I are particularly interested in. So instead of there being kind of inaccuracies in the data input or the data output, what if there's actual garbage in the middle? Yeah, so data protection law doesn't seem to be the solution to that. And if you take the example of facial action coding, so that's the idea essentially that facial expressions reveal emotions. So if you through machine learning techniques assess people's facial expressions, you get an accurate indication of what are known as basic emotions, so emotions that are perceived as universal across society. But there are serious question marks over whether that is actually scientifically true or whether it's a mere pseudoscience. So if it is a mere pseudoscience, how do you regulate that pseudoscience in the middle, the garbage in the middle? So in Europe, there has already been some discussion about this. So in the proposed AI Act in the Commission draft, there were transparency requirements being suggested. So, that was the plan, but then there was some kickback following on from that. So you had research institutes, but you also had, actors like the regulators, such as the European Data Protection Board and the European Data Protection Supervisor saying, okay, well, these systems are completely inaccurate. They're potentially very harmful. They could lead to unfair outcomes. So we should ban them. Essentially. And there were lots of interesting debates as to, the role of policymakers in effectively designing rules and deciding on what could be perceived by some to be scientific debates. But the outcome of it so far, from what I can see, is in the compromise version of the AI Act, from the various leaks that I've seen so far, and I suppose, the discussion of it has been that there is a proposal to ban certain AI or emotional AI in certain contexts. Yeah, so in the areas of law enforcement, in border management workplace, and in education context. But then this leaves open other areas. So although it may highlight them as being high risk, it certainly wouldn't seem to ban them in the context of consumer devices, which leads us, Jeannie and I, to start questioning, okay, well, how will the law regulate this inaccuracy? And what other means of regulating them actually exists, both, I suppose, within statutory protections, but also in the general law. So I'll pass to Jeannie now and leave her finish off the presentation.
Right. And Damien, will you keep moving the slides?
Yeah, no worries. Yeah.
So we don't have to put them up again. So if you move, oh, fantastic. So as Damien has indicated, the proposed compromise AI Act ban on emotional AI leaves open questions how to regulate consumer-facing products. And we're all familiar with sort of the regulatory design question. And there's a number of choices in this context, and the choice really depends on the focus of concern and how we characterise the harm arising from products that may rely, in this case, on emotional AI. And I think that's something that Damien and I want to investigate, because we don't think it's really that clear in discussions around the AI Act. So is the concern inaccuracy, pseudoscience, or is it the potential for manipulation, or even the potential for sort of being inconsistent with fundamental human values that may come from the use of this technology? And whether you think the concern is inaccuracy, manipulation, or fundamental inconsistency with values of democratic society will probably influence the intervention that is made in relation to consumer-facing products using emotional AI. And the choices you can see up there. So we've got sector and even product-specific safety standards as an ex-ante response. We've got a sort of misleading approach, FTC, Fair Trade Commission approach, an onus for transparency in the use of the products. And then we've got an interest in paternalism. Now, Damien, can you just go to the next slide? Yeah. So product safety standards, we're pretty familiar. There's been lots of discussion today about the role of product safety standards and the fact they're the ex-ante approach, but they also have an enforcement element with product liability. Next. Then we've got sort of general consumer law protections, which may come with a focus on unfair and unconscionable practice, misleading conduct, misrepresentation, deception, and also substantive standards that we were talking about in our last session about just the quality of the product. But as you can see, that type of intervention depends on what you think the problem is. Is the problem inaccuracy or is it something else? So sort of consumer warranties deal with the inaccuracy, but they don't necessarily deal with manipulation. Unconscionable or unfair practices deal with manipulation, but not the conflict with fundamental human values. Next slide, Damien. There's a question about contract terms, which we probably don't have time to deal with, but I think sits across this whole area of what happens. How does what's happening in the contracts, the supply chain contracts, affect consumer protection values? And next slide, Damien. We come to the idea then of bans. Now, this is really where Damien and I are most interested, because bans aren't talked about very often as part of our consumer protection toolkit. And in fact, they're often regarded with a little bit of horror. Because, we shouldn't ban things because that limits the market and removes consumer autonomy. But, that's not necessarily the case that bans are problematic if we're faced with a product that is more problematic to us. And so we wanted to unpack the reasons for bans. And I'll just briefly note here that bans can be justified on two bases. One might be paternalism. We ban products that we think consumers don't choose well about in order to protect them. Or we may have bans for matters of public policy that society generally wants bans. So bike helmets, mandatory bike helmet rules are an example of paternalism. Consumers have optimism bias, won't wear their bike helmets, so we have a rule making them mandatory. That does have a social benefit, but it's based on poor choices by consumers. Prohibitions on buying and selling organs are based primarily on public policy. We think it is bad in society to have that sort of market, though it may also have a protective function for individuals. Now, the question that Dave and I will look at is really, where do we land with emotional AI? And that comes back to that question of what are our concerns about its use? And is this perhaps bans actually a legitimate option, either because we think that emotional AI is so manipulative, this is something that consumers can't choose well about, or because we think that a fair and just society doesn't categorise people according to the way in which their emotions are registered by some external system in order to determine their access to good service, medical treatment or whatever. The final point we're quite interested in, and I will finish here, is that, bans are generally seen as an example of an overreaching state and a restriction on consumer autonomy and well-being, but would actually suggest that bans properly designed can actually perhaps enhance the operation of the market and consumer autonomy and well-being, because we're removing an element of concern and sort of poor choice making, giving greater scope for that market to operate with systems that are perhaps more beneficial to consumers and society generally. Yeah, that's where we're going. Anything else from you, Damien?
No, I think that pretty much covers it. So I'm looking forward to any questions.
Thanks. That's us.
Thank you,
Lisa. Look at the time.
Thank you so much. I managed to unmute myself, and this is absolutely amazing because you didn't go over 20 minutes. We appreciate this. So let's move on to the next speaker, Professor Rostam Neuwirth from University of Macau. And ladies and gentlemen, he wrote a book that will be converted into a hit Netflix show very, very soon, a book on subliminal AI. So you can either attend today's talk or just wait for the Netflix show. Rostam, the floor is yours.
Thank you, Elisa. Thank you very much. And thank you for the organizers to have me. I hope you produce the Netflix show because so far I haven't signed any contract. But today I will stick to the book that is already ready. And I will share now my slides. I hope you can see them. Is it visible to everyone? Yes? Okay, good. Yeah, so the background is a book I have written actually on only one single provision in the AI Act, which is one of the prohibited practices. So there are 4, and I've only focused in with the whole book on these subliminal AI systems. I've also published an article a month ago in the Computer Law and Security Review on all 4 of them, and that's also interesting. Maybe we can discuss that later, how these different provisions relate to each other, but it is already enough to show how difficult this one provision is to interpret, and also, I think, to adopt and ultimately also to enforce. So I will have more questions actually than answers, as the title says. Just for the background, I think everybody is aware of the fact that now the debate has moved from the development of AI to the regulation of AI. And we have seen, importantly, the EU coming forward with this proposal for an AI Act. China too, just I think a month ago, followed up with also draft measures now to regulate, not just ethical standards. And UNESCO from November 2021 is also important because I think it reflects at least an emerging global consensus that AI is not just a miracle, but also raises serious concerns. And then the Council of Europe is also working on a binding convention now on AI. But I will focus only on this Article 5, paragraph 1, littera A, which deals with and proposes to prohibit AI systems that deploy subliminal techniques. And the others are those that exploit vulnerabilities, social scoring or credit systems, and then real-time remote biometric identification systems. So only the first one is the one that I think is already interesting, because I think it's a game changer in terms of the new technologies that are available to us and how it will change our understanding of human behavior, and also in particular the possibilities to influence that kind of behavior. So I think we also have seen in a recent book that came forward, the battlefield right now is the mind in many ways. And I start the book with this saying that if you don't control your mind, the mind will control you, which I personally know how difficult it is to control my mind. But once you lose control over your mind, it's also easier to control your mind. I mean, for someone else to control it. And I'll show you how neuroscience here proves that. And of course, also these technologies raise a lot of questions for the fundamental rights, but for law in general. And for maybe there is a need to amend our understanding of the right to freedom of thought, to a whole new kind of right of cognitive liberty. So here is an article from 2014 already that says this right to freedom of thought is probably has been in the shadow too long and needs to be updated to something that helps us to protect our cognitive liberty. And the UNESCO recommendation also immediately recognizes the importance of the human mind, because these technologies, AI and so on, allow for new ways to influence human thinking, our interactions, and even the way we decide, and also the way we behave. And that I will show also briefly how this is being scientifically supported now. So this sentence that I discussed in my book is this one on the left. Just 2 days ago, the EP published also this compromise text where there are some changes. I think it doesn't change substantially, it just makes it a bit longer, and we could maybe discuss that. But the point is, for me, in this sentence of basically prohibiting an AI system that deploys subliminal techniques beyond the person's consciousness, and then it has to distort a person's behavior and cause also kind of harm, physical, psychological, and in the compromise text is they replace that by significant harm. I think what interested me particularly was the whole set of regulatory and interdisciplinary challenges that come with this one sentence. And they are basically, you could divide them into legal challenges, psychological, scientific ones, and technological ones in a way. So I will not speak too much about the legal ones, just to mention here that also what other commentators raised about the AI Act, especially this harm requirement, that it is too narrow. I still would say significant also is still too narrow. We have to probably find a new understanding in terms of harm that takes into account collective forms and also cumulative forms of harm, which is of course difficult to attribute then to a certain person or a certain entity. There also a major challenge is how this act relates to other acts. And for example, the Chinese draft measures say that all existing laws have to be applied to that. Who is capable of understanding which are all the laws that are actually applicable or relevant to a certain like act or even just one provision? It's very difficult. And I mentioned already fundamental rights, and also enforcement is a major problem. It's a paradox actually, because if subliminal means it is below our awareness, so how do you detect what cannot be detected, right? So this would be also an interesting question. Psychologically, the most important thing for me was that to understand what is subliminal. What does it mean? The act does not really provide any clarifications as to the meaning of the term. Also a question is, of course, when we say there is a threshold, for example, between awareness and unawareness of a sensory stimulus, which senses are we talking about? Is it just what we see, what we hear, what we smell, what we feel, touch, etc.? And here it's very interesting to ask also, how many senses do we have? This is also something that scientifically is not as clear as it seems to be. Instead, what I learned from the research is that in the past, the focus of research was always on one sense and less on the interaction. But I think what is interesting legally here, that we have, for example, AI with other technologies, emotional AI, etc. The problem will be the combination of sensory information and stimuli that can actually, I think, enhance the efficiency of these manipulative tools. And here the problem is that Article 5, I think we might have scenarios where a certain product, a certain service may not violate a single one of these four, but in combination might be violating all of them in a way. So this would be an interesting question that requires also an understanding of what is subliminal perception, what is supraliminal perception, etc. And is there a threshold of awareness? I will also look into this at all. And then technologically, there are a lot of questions. What is AI that is subliminal? Does it exist? What will be future AI systems of that kind? Because we want to future-proof the legislation, ideally, and not just amend it with every update to ChatGPT or something. And then what are like the combined effects of those, and ultimately also how do we make sure that they will be regulated in a way and also enforced, of course. So to begin with, the subliminal perception, I just want to mention briefly that this is a phenomenon that was studied a long time ago in Austria, actually. There was a psychologist who did experiments and was able to prove that some kind of subliminal visual stimuli remain in the brain, even though the person wasn't aware of it, as it was then drawn in dreams, from the dreams that test persons reported. The interesting thing is that apparently this information, this psychological understanding went to the US, where the interest was less in psychology, but more in how can we make consumers buy the products. And this James Vicary became famous for this experiment that allegedly took place, where he screened in a cinema, flashed these images subliminally of drink Coca-Cola, eat popcorn, and then sales went up in the break or after the show. I will not talk about the history here more. There's only one more interesting book, 1957 too, that actually made these Vicary experiments known, where the author warns of these subliminal tactics, as he called it, that you can manipulate consumer behavior. And not only that, he also warned already of probably manipulative effects for politics and elections, which I think is quite pioneering when we think of Cambridge Analytica almost like a century later. Interesting is also to mention there were lawsuits against rock bands in the US for allegedly having embedded like subliminal messages in their music, which has prompted teenagers to attempt and also to commit suicide. These lawsuits were not successful, I guess, mainly because of the problem of proving the causality between the two kind of things. And so, but it is interesting that that was in the 1990s. There was already, even in the courts, were kind of confronted with the notion of subliminal techniques. And then the most recent findings from neuroscience suggest that actually the major part of our cognitive functions operate below that level of threshold. So we are not aware of most things we do on a daily basis. No matter what you decide to eat, you drive a car, most of these things are now below. Of course, I guess it depends a bit on how familiar you are with a certain practice, I guess. But generally, the consensus in the studies that I found is that most of it is below that threshold. We are no longer fully aware of that, which means for me that if you have access to that pool of 90, 95% or more, I think the chance to manipulate behavior is much higher than in these 5%, where I might be aware, hey, this guy is trying to sell me something. But if it's all below that awareness, it might go in and I act and I don't even know I was manipulating. That is really, really important. And in this respect, it's also interesting to say that studies now have pretty much confirmed, I think, that the subliminal techniques are working. They have an impact, not only on our thoughts, but also on our actions. So they change our behavior, materially distorted, if you want. And also what they note is that it is the combination of big data profiling and the possibilities of place advertisement individually to those who you're trying to target, that is enormously enhancing the possibilities of these tools and subliminal techniques. And it is being very much applied already in modern subliminal techniques of advertising. And I think with also this research and techniques, technologies developing like augmented reality, virtual reality will further enhance these the possibilities for manipulation in this sense. And Dirk Helbing, for example, I think summarized it quite well. We move already from programming computers to programming people. And I think this is not an exaggeration at all, unfortunately. So now I come to the second question, is there such a threshold? So this is what I learned is about psychophysics to find out whether we can draw a line for each sense where we are aware and where we're not aware. And to cut a very long story short, I think there is no such threat. I mean, it's not me who thinks it. It's Pamela Smith and Kathleen McCulloch in a great chapter summarize that there is no such threshold and there isn't even one interpersonally. So everyone is different in that sense, and even intrapersonally. So my threshold of awareness changes probably depending on whether I'm tired, I had a beer or not, or something like that. Which from a legal perspective, I think is difficult. How do we try to draw where do we draw the line and how do we enforce that if there is no, at least a universal or near a universal standard for establishing whether something is subliminal or not? I propose in the book the term transliminal. I think it would be more dynamic, would more reflect the kind of actual psychological reality. And finally, I come to the subliminal AI systems. What I found here is that it is very difficult to, because the notion of AI is vague, it's dynamic, it's evolving constantly. So I didn't even spend much time on a definition, to be honest. And I tried to find out at least what are technologies that in combination may support these technologies that we term then subliminal AI systems. What is clear is I think that AI is about replicating and artificially the human mind, which is why it is such an oxymoron as well that combines human and artificial intelligence. Just to give you an example from neuromarketing in a way, you probably all know if you book a hotel room on one of those booking platforms, they create these, what is also known as dark patterns. And I think dark patterns are a synonym to subliminal techniques in a way, because they use very sophisticated psychological tactics to create a situation of carrots and sticks, like, 60% off, great deal, I want to buy. But then at the same time, 5 people already looking at it, right? And then only 5 rooms left. So I'm excited and I'm stressed, and click, I book. And actually on another platform, if you call the hotel, you would have had a better deal, and even weeks after probably. So this is not really subliminal, I think. But then I came across a study from 2020 where they just took a video of a 360-degree video showing this hotel room, and they showed it to some test persons just as it is, the video, 360-degree, and another one with one subliminally embedded emoji, a smiley basically. And these test persons apparently liked this room and were willing to purchase it to a much higher degree than the other group. So if this is true, I think if just a smiley can make me so much happier to buy a product, then I don't want to know what other techniques can achieve when we apply them subliminally. And we combine, for example, sound, smell, and many more of these techniques that are there. I can just tell you, like in Macau, if you go to a casino, every air condition has a particular fragrance. And I have realized how this fragrance stays in my mind. And you associate a good dinner and you smell that again, you want to have the same dinner again. It's really powerful, I can tell you. So be aware of that when you come to Macau. And ultimately, one technique that I think shows these possibilities is a study here from 2012, apparently, where they already were able to use subliminal techniques combined with other techniques and fMRI and so on, and PCI, computer-brain interfaces, to extract very, very personal data, PIN codes, birth dates, etc., from test persons. So this at the time was in the laboratory. Now, if you read maybe in The Guardian just a few days ago too, the AI in a non-intrusive way was able to connect fMRI images and make them into basically decode these electronic signals into text. And that means you can read the mind. So I guess this is already pretty much state of the art, and I can't even imagine what future technologies will bring when we combine all these together. And that is going to be a very powerful tool. And just another interesting aspect is also that I came across with the help of colleagues and so on, that it is also not safe, like we heard already, inaccuracy and so on. There are interesting studies of these adversarial attacks, for example, for biometrics, that you can apply a makeup, you can wear sunglasses with certain patterns, and then you can manipulate the biometric system into believing I'm someone else. And this is just interesting because I said AI is a replication of the human brain through artificial means. And it seems to me that you can also subliminally manipulate the computer back, the AI back. It's always a loop. We are creating actually with AI, I think, just a mirror image of ourselves, which is why I think we should not ever talk about our AI at the same level as human intelligence. And that's why I conclude basically that AI is an oxymoron. It's a misnomer. It is actually misleading in many ways, and it is a false invitation to give up, I think, the free will, the human cognitive liberty, and therefore, basically, for the reasons that I also mentioned in terms of perception, supraliminal, transliminal, etc., we should not give up that monopoly of human intelligence in a way, and we should not give up the responsibility, not hand that over to machines. And for this reason, I think I conclude AI must be regulated. And for the rest, I apologize that I have no more answers, but this fundamental one, and I look forward to the coming questions and coming discussions and presentations. Thank you very much. I hope I didn't exceed the time.
Thank you. Thank you so much, Rostam. This was slightly depressing. Not your presentation. Sorry, that came out the wrong way. I mean, not your presentation, just the state of the art. Okay, we have some time. So now, ladies and gentlemen, without further ado, Professor Lutz Christian Wolf, AI versus humans in the law of obligations. The showdown. Actually, I'm thinking I should have put you last for the showdown, but sorry. Okay.
Thank you, Elisa. Hello, everybody again. I must start by saying that I'm also very worried about my booking practices when I go for hotels, because I do exactly that. I look at these platforms and then there is this thing, only one room left, but that's a different story. What I would like to do in the next 20 minutes or so is to discuss if machines will take over the law of obligations, if machines should take over the law of obligations, which of course depends on whether this is technically possible, and if so, if we should allow this. And we've just heard that we shouldn't. I'll give my opinion on this point as well. To answer this question, I think we need to look first at concerns regarding the delegation of legal work to machines in general, and then in a second step, look whether those concerns also hold water in relation to the law of obligations. I should also mention that my presentation is based on a paper which I prepared about 4 years ago, where I tried to discuss whether AI is really that bad. And I must admit that I did not expect this to become so controversial over time. A lot of skepticism vis-a-vis digital legal decision-making, AI and legal technologies, is based on the belief that the current state of computer technology does not allow the comprehensive use of legal technologies for legal decision-making purposes without abuse. I want to add that. And in fact, the comprehensive use of AI systems of legal technologies in this regard requires a perfect AI world where AI systems have unlimited access to information and data, which can be processed without any technical or other constraints. And obviously, we are not there yet. The current state of hardware and software technology does not allow this. It only allows it to a rather limited extent. And the question is whether this will change in the future. Now, I cannot discuss, of course, technical aspects of AI. In particular, I'm not able to predict the development of AI, but just want to remind ourselves that the emergence of ChatGPT has been really a powerful wake-up call. And AI experts are rather optimistic. Here's a quote from 2016. Combined results from surveys of artificial intelligence experts estimate a 50% chance of human-level machine intelligence by 2040 and a 90% probability by 2075. And this is my starting point today. I will adopt these predictions and assume that a perfect AI world, or at least a world where AI or other legal technologies are as good as humans in terms of legal decision-making, that this world will become possible, will become real in the future. This also means that many of the arguments which have been so conveniently put forward against the use of AI can no longer be valid. In contrast, the technical viability of digital legal decision-making is not, that is not an issue. The discussion, I believe, can focus on the real core questions, and that is if it is desirable to replace human legal decision-making with decision-making by machines in general and in the law of obligations. Now, before we get to the law of obligations, let me briefly recall the advantages, perceived downsides of digital legal decision-making. Compared with human legal decision-making, digital legal decision-making has 4 major advantages. Speed first. Due to the automated mode about which we have heard earlier, digital legal decision-making can be conducted instantly, is therefore faster. Second, accuracy. AI processes data and other information in an automated manner, and digital legal decision-making therefore guarantees absolute accuracy because any deviation from the preset process does not form part of the notion of automation. We've discussed it this morning. Again, I assume this perfect AI world where we have full automation capabilities. Third, consistency. Automated legal decision-making will ensure that in the same circumstances, the same decision will be generated. And finally, efficiency, of course. AI does not, and legal technologies do not depend on manpower, and therefore there is a much higher degree of efficiency. And this translates into obvious advantages from the rule of law point of view. provided that the underlying algorithms are set correctly. Digital legal decision-making involves an automated process of collecting and processing data and other information, ideally leading to absolute predictability. In a perfect AI world, I argue, digital legal decision-making can ensure 100% implementation of a core element of the rule of law doctrine, the requirement of legal certainty. And of course, the second point is that digital legal decision-making can potentially expand access to legal information and reduce the duration of judicial proceedings. And this can therefore improve access to justice, which is another important feature of the rule of law, at least the thick rule of law concept. The perceived downsides of digital legal decision-making can be divided into two categories. First, there are doubts about the technical viability. And second, many commentators have questioned whether legal decision-making should remain with humans. We've just heard that from Rostam. Again, I will assume, as for the first category, the main concerns raised are shown on this chart. And again, I will assume the possibility of a perfect AI world. I will also assume that an abuse of AI can be prevented. And that means that it will be possible to address all these concerns by building a proper system. And I will not go into these issues further, but rather focus on the much more interesting aspects, I believe, against the use of AI, and that's arguments which, on the face of it, do not relate to technical aspects. First, AI is a job killer. It's quite commonly acknowledged that AI will increasingly replace many jobs. For the legal industry, it's estimated that half of the legal jobs will go within the next 30 years. But as with other technological developments in the past, of course, it appears that given the major advantages of legal technologies, this is not a good argument against innovation. Probably a side aspect is the end of legal creativity. If one acknowledges that the delegation of legal decision-making powers to machines implies automation, then the decision-making will lead to the end of legal creativity. And this is because in a perfect AI world, digital legal decision-making will be fully automatized, thus leading to the one and only correct decision, or at least the best amongst different options automatically. And this is nothing bad, of course, because legal creativity is not a goal or value in itself, but rather a means to find the best solution. Democratic legitimization, Damien and Jeannie have touched upon this before. Commentators have argued that digital legal decision-making lacks proper democratic input. And that's, of course, a powerful argument, at least for jurisdictions with democratic systems. Now, the initial delegation of legal decision-making to machines, that is the decision to enable digital legal decision-making, should not raise any concerns unless the delegating party lacks the legitimate power to do so. What would, however, I think be problematic is if such delegation was forever. And if that's the case, if the decision to delegate decision-making powers forever to our AI systems, even if that decision was democratically legitimized, it would be a decision to abolish democratic participation forever. And even on the assumption of a perfect AI world, I believe this is not acceptable in societies where democratic participation is a core value. Can this be addressed? I believe yes. I believe it can be addressed by building systems which put in place human oversight, governance, through monitoring and scrutiny mechanisms. How such a system has to look like, of course, is a big topic of discussion. We have heard about this a lot today. Many commentators have argued against the delegation of legal decision-making powers to machines because decisions, or at least major decisions, should remain with humans, so to speak, to preserve the human elements in the legal decision-making process. But which human elements are we talking about? Human errors, emotions, delays? Why should human elements be of any importance, I ask, if machines are faster, more accurate, and more efficient? Admittedly, algorithms are technocratic and dispassionate, as some have put it, but legal decision-making has to be technocratic and dispassionate to ensure absolute objectivity and thus allowing a predictable decision-making process. There is no room in any legal decision-making, whether digital or not, which is for decisions which are not objective. And again, this is the major advantage of digital legal decision-making, of AI systems, of other systems. Human elements can be excluded here. The only human aspect I can see that must be considered in this regard is human dignity. And we have heard from Damien and Jeannie about that, and Rostam has mentioned that as well. If all legal decision-making was delegated to machines, humans would be legally infantilized and their existence in the legal sphere would be de facto extinguished. And that creates a dilemma. If one believes, on the one hand, that the ability to decide one's own fate is the essence of human existence, then absolute digital legal decision-making cannot be accepted without, despite its advantages. On the other hand, in a perfect AI world, digital legal decision-making would lead to the creation of perfect laws, regulations, and their execution without errors, omissions, delays, and so on. And if perfect legal decision-making is the ultimate goal of a legal system, then digital legal decision-making must be preferred over human legal decision-making simply because it's the superior way to achieve justice. I will leave this issue for the moment and now finally turn to the law of obligations, which I think will help us to accentuate this issue even better. What do my general observations mean for the law of obligations? First, I wish to acknowledge that the term law of obligations is used in different contexts in different ways. For us, I think it's sufficient to think about contract tort and the law of unjust enrichment. Now, the law of obligations is a rather technical area, one can argue. And the question is if the concerns which I've just highlighted are also valid here, or do the major advantages of AI require us to hand the entire law of obligations over to machines? In other words, if machines are faster, more efficient, more accurate than human legal work can ever be, why should we not delegate all the work in the law of obligations to computers? And again, this is a thought experiment. I am well aware of the fact that technically we are not there yet, but I've said that out earlier. AI experts think at least we get close. Now, to highlight the considerations which are important in this regard, I like to present two scenarios. In the first scenario, legal technologies are only used to support the law of obligations, to draft contracts, negotiate contracts, prevent contract breaches, identify tort scenarios, enforce remedies, determine appropriate remedies in case of unjust enrichment scenarios, and so on. Here, AI or other legal technologies support the law of obligations. And all the advantages of AI, which I've outlined earlier, could be utilized. And that's why I think nobody would object to this kind of use of AI and other legal technologies. Scenario 2 is completely different. AI takes a much greater role. In fact, AI takes an absolute dominant role. AI manages society by allocating wealth and goods, by comprehensively organizing, governing person-to-person relationships, which will then lead to an elimination of the need of contract law. It will prevent torts. We don't need tort law, and there will be no unjust enrichment scenarios because humans are not involved. Scenario 2 is scary. Scenario 2 leads to all those concerns that I have outlined earlier. Human involvement in the law of obligations would be eliminated, abolished, and this, I trust, is not acceptable. The problem is that with any delegation of work in the law of obligations, and actually in any other area of law, with any tiny bit of delegation of work to machines, we are moving away from scenario 1 and we are getting closer to scenario 2. And we need to ask ourselves if we should do this and how far we can go. And with this, I'm already coming to the end of my presentation. It will take decades, I believe, until digital legal decision-making will reach the level of will have the human abilities. But as mentioned earlier, according to AI experts, this possibility is real. To get there, many technical problems need to be overcome, many risks have to be addressed, but I believe that these problems, risks, must be accepted because of the competitive advantages of legal technologies, of digital legal decision-making over human legal decision-making. The question of the century is how much legal work we should delegate to machines in the law of obligations and in general, and how far we can depart from that acceptable scenario 1, and how close we should allow ourselves to get to scenario 2. I don't have an answer, I must admit, but it is obvious that this question will take center stage in the years to come, and this is what I wanted to highlight today. Thank you very much.
Thank you very much, Lutz. We have more time for Q&A, and I'm getting so many questions that I will just take forever to read them. Okay, so ladies and gentlemen, we have more time because all the speakers were extremely disciplined with keeping their time. I really appreciate this. So it's probably the one and only session where you could have gone overboard, but okay, too late for that. Now, okay, the first question is for Jeannie and Damien. Okay. Bans are often criticized as hindering innovation, so that associated AI developments, even beneficial ones, then occur elsewhere to the detriment of the domestic economy. Is this a valid argument in your view, and how it can be addressed? Because we saw the absolute overboard AI regulation in the EU. There were some bans and some really, attempts to curtail the development AI. So is the word ban or the practice of banning things, is that a good thing? Jeannie and Damien, are you hindering innovation?
Jeannie, do you want to go first? Or?
I'll be really quick. I don't think you're hindering innovation. We have bans in other areas. I think the difference or the interest we have is how we nuance those bans, and the sort of awkwardness of the AI Act that we keep hearing is this sort of one size fits everything. And I think we're probably interested in a more nuanced approach, both in terms of the policy and also the application. Damien.
Yeah, no, I agree, obviously. And I suppose, ban is a big word, but, you can think of specific harms as well that you can kind of counteract. The emotional AI example is one where I think I would feel that a ban might be justified, even in a consumer context. But you could, from a policymaking perspective, look at other potentials there. I mean, you could ban its use for the advertising of particular products or the targeting of the sale of certain products. For instance, with certain pharmaceutical products that are already heavily regulated in terms of their advertising. So, there are a range of options that you can use that policymakers would have to consider when they're looking at bans. And that's, I suppose, going to the point that Jeannie made towards the end of the presentation around the fact that bans can actually enhance consumer autonomy as well, in the sense of having better options to choose from rather than having bad ones that should probably be removed from the market. I think you're in that. Yep.
I can unmute myself. Oh, thank God. Okay. Although the question was technically, I think, addressed to Ginny and Dim, I think Rostam, could you? What are your thoughts? Because we have a ban on subliminal techniques, but it's really badly drafted. So I think my impression is, if you want to ban something, make sure you ban the right thing.
No, thank you. Absolutely. I mean, ban in the case of Article 5, it's prohibition, which is basically the same. But I would say the problem comes first also that we should address is it even going to be efficient to ban it? Because I think planned is to prohibit these practices, but I think it will not be enforced, because I looked at the precedent of subliminal advertisement on TV, which is banned in all over Europe, the Council of Europe member states and the EU member states since 1989. And when I talked to the regulators, none of them really could give me a case. So I think, and the paradox here is, if it's subliminal, actually it's undetectable, right? So how to detect the undetectable? So I think we need to completely, of course, remodel our understanding of the law, and also transcend these binaries of duties and rights and also prohibitions and recommendations, I think. So it's much more complex. And I think a lot of this will also lie in what Lutz mentioned. I mean, we will need the assistance of technology. It's a bit like, a paradox to use the same technology that causes the problem to solve the problem. And again, I think the major problem is a cognitive one, and that's where lawyers should focus their efforts on. Yes, I hope that answers that.
Can I just continue? I'm just going to monopolize this conversation for like 2 minutes. Can I just continue with your commentary on Article 5? And please, everyone, I'm not getting a commission from Routledge. I think, was it Routledge? I'm not making money from promoting Rostam's book, but the book is actually really, really scary. But I really got into analyzing the AI Act in Article 5, and I was just looking at the revisions from a couple of days ago. And what struck me is, like, going back to this thing, like, if you want to ban something or prohibit something, make sure you ban the right thing and you word it correctly. So I have the impression, and you briefly mentioned this, just to confirm my understanding, that we have this really vague word of subliminal, which is like, it makes no sense because it's the stuff you can't detect. So I think this is the Google and Amazon lobby here at work. Because if you can't detect it, you can't detect it. It's not effective. It doesn't cause anything. But the overt manipulations, the manipulations we feel and perceive, they're not prohibited. So am I right? Or is my reading correct? Like the hotel room example.
Yeah, absolutely. First of all, I'm not making money on Routledge either, but that's another story. The point is that you're absolutely right. I think that this term is misleading, and I also think that the main expectation I have towards the AI Act and Article 5 is not the legally binding effect and the enforcement at all. But I think by screaming prohibition, act, and not ethical recommendations, you have a debate. And I've seen that in other fields too, in international cultural law, for example, with the UNESCO Convention on Diversity of Cultural Expressions, that before there is a clear proposal for a law or a treaty, there is no serious debate. And afterwards, there is no legal enforcement, unfortunately, but there is a debate that leads to certain follow-up, I think, legal or semi-legal kind of instruments that make a difference. And that's where we are right now. I think we need to first create that debate and also basically force those all involved into being aware of this, and also educate the public and future generations.
If I can jump in there, I agree, but I also think that it's not enforced is a bad reason not to have law, because enforcement is actually a choice. You give money to your regulator or you don't give money to your regulator. So I absolutely agree that having a law is a really good way to prompt the ethical discussion. I think that's exactly spot on. But I don't think, it won't be enforced is a good reason for saying the law won't work. The law can work. Just give the regulators more money and they will make the law work. You know, and the manipulative stuff is really interesting because actually we are seeing movement on that. Dark patterns is actually a subject of attention in lots of places, and it may be, and I just keep harping on about this, I think the AI Act is just trying to do too much. You know, there's a really good proposal in the US on dark patterns, but still important, and just starting to make some rules about dark patterns which are then enforced under more general consumer protections under the FTC Act. And I think that's exactly what we want, that we want to raise concern, think about the way to address it rather than grandstanding. And you're not grandstanding, you're making, that's not a comment about your comments, Rostam. I think they're entirely right.
Okay, I really wanted you to say all this because I'm sure whenever EU does something, everybody else starts debating it. So for the benefit of the Hong Kong public, we can actually learn from EU's mistakes. You know what I mean? Like before you start drafting, let somebody else do it and be the last one to enact something. Okay, I can see Larry is here. Awesome. Larry, can you hear me? We can't hear you. We can't see you.
I can see you.
Oh, beautiful. Hello, Larry. It's so good to see you.
May I say hello to Carolina Mick? I never knew your middle name. So
oh, my God. Larry, okay. Listen, you have 20 minutes. You're the last speaker. And leave a little bit of time for Q&A because we still have some questions. Thank you.
Please feel free to interrupt me. And,
I will.
I'm going to ramble really quickly because I'm a big talker. And so I have quite a few slides here. I'll talk very fast. First of all, I'd like to thank Norman Whitesleb for the invitation and a very nice set of speakers, including some friends and old colleagues. And I'm going to really focus on digital trade, but clearly applicable to anything to do with AI and new technologies. As you know, big data is the sort of the fuel that makes the engine run. And without it, we'd probably not be as concerned with AI decision-making and things like that. So first of all, we are in the process of building a legal infrastructure. This is, of course, stuff that has been talked about for more than a decade, maybe now. And I just put a list there of different things that continue to need to be developed as a part of an infrastructure. And sort of listing the main obstacle to sort of dealing with new technologies, and that is the idea of uneven consumer protection laws and privacy laws, and how do you fit that into a global scheme? And clearly, there will be some sort of regulatory competition in that area, and the European Union is far ahead of other places like the United States and China and places like that. I will be talking a little bit about the borderline between the public regulation and private regulation, what is known as the public-private distinction, and pretty much advocating not forgetting about the power of private law, whether it's contract law, tort law, personal property law, in regulating big tech. So how do contracts apply to digital trade or transporter transactions? This is an old question, but it's clearly answerable in one phrase. These are all transactional activities, and therefore contract law will play a viable alternative to sort of balancing the dangers of big tech and new technologies, in the sense that contract law has always had a second function known as the regulatory function. And so when we're in our courts of law and arbitration, that side of contract law comes to bear. And public regulation aside, courts are generally in the position of striking a balance between the dangers and the abuses and the exploitation of consumers and other parties. And so it's important to remember that. Does blockchain technology potentially coupled with AI sit outside the ability of contract law and targeted regulations? Well, this is what we call escaping the law. We see this in private law systems, like in the cotton industry and the diamond industry, where the things never go to court. And are handled within, institutions set up by those industries. But ultimately, as the shadow of the law is always lurking, and therefore they can try to avoid the law through these sort of self-executing mechanisms. But at the end of the day, when somebody feels wronged, they will seek recourse, either in arbitration or in courts. So the digital commerce issue is, how do we deal with things like data and codes and stuff like that? Are they personal property? If so, and not per se intellectual property, but personal property that would be covered under that type of long-standing legal regime. Example would be the transfer of crypto tokens. So in negotiable instrument law, we've always had the idea of a good faith purchaser, someone who purchases illegal things and yet gets good title to the property. If the data has been illegally acquired and then resold to a good faith purchaser, and some people have now, or scholars have talked about the innocent acquisition rule, which would be, once again, a example of the flexibility of law, taking the concept from negotiable instrument law and creating a term that would apply to data transactions, digital products, digital services. So the regulation of data is, of course, of prime concern. Data rights is really an important concept, and the GDPR, of course, goes a long way in listing the type of rights that parties should have, and these should be made applicable not outside of privacy law and into areas like the quality of the product and stuff. But getting back to contract law, the key private law area, we have a host of general policing doctrines. We all know them, and clearly they can be brought to bear on any sort of transactions, whether with AI or in the transfer of data. We have the technique of blacklisting that we get from the Unfair Contract Terms Act that should be applied. There will be a need to develop data-specific and AI-specific torts. A lot of this focuses, of course, on the liability and responsibility question of, can the AI system itself be held liable, along with its producers and operators and things like that. Post-mortem data is something that has to be addressed. When someone passes, what happens to their personal data? Can the heirs to that data, in a sense, ask for an erasure of the personal data of the deceased? There has to be some sort of mechanism to allow this to happen. And of course, a more liberalized regime for research-specific use. Scholars and academics, scientists, whatever, need access to big data, A, to use it in a scientific way, and B, to see if something untowards is happening in the use of that data. Transparency policies are one thing, actual transparency is something different. And so we need specialized rules, and whether it's the sale, leasing, licensing of AI-related IP or the transfer of data. And of course, privacy rights can be protected through some sort of anonymization or cleansing of the data to make it more like what is called synthetic data. Now, there's, of course, a lot of initial proposals, projects, poking around, if you will, on the development of a digital assets law. There's a English and Wales Law Commission paper 256, which I urge you to read, has some good ideas in it. Digital commerce has put a strain on private law and how it actually engages here. Clearly, there's a bunch of contractual uncertainty when you're talking about things that are really so highly technical. It's hard for a practitioner or a judge to actually deal with what is the contract and what should be recognized. If it's a form of property, what type of property would that be? Once again, is the code personal property? Is the data personal property? And finally, unjust enrichment clearly has a role to play here when parties extract data and benefit from it in an improper way. There should be some sort of compensable damages, an unjust enrichment by the party taking the data. I'm going to step away because I have a runny nose. It is sad that when you're 65, you lose control of your bodily functions. So normally I would have a hanky here, but I was a rush because it's early in the morning in Florida. So I will skip ahead to what is now developing a digital contract law. We have these two European directives, the contracts for supply of digital content and digital services. And once again, this is a terminology issue. By digital, I'm generally talking about things involving AI and the processing of data. We now have the first implementation of these directives in the German Civil Code, which is interesting to look at. This new section 327 on digital products at least gives us some sort of definitional boundaries as to what we mean by digital content and digital services. And you can see the sweep is very broad, and as to what people do in their lives from a day-to-day basis is pretty much covered by a lot of what you see that this new regulation pertains to. It's a contract based on either the payment of money or more likely the sharing of personal data is the consideration for the use of digital products and services. The law provides a bunch of seller obligations, that is, the seller of the digital product, the data, that sort of stuff. So the digital product now has to come, in a sense, with a lifetime warranty. That is, the expected duration of that product is guaranteed in the sense that if the product needs to be updated, the tech company has to provide the updates free of charge for the duration of the lifespan of the product. So we see in the way of quality issues, it also impacts warranty law, suitable for ordinary use based on industry standards. It not only has to work, it has to be compatible and functional and interoperational with all sorts of other things in possession of the consumer. It has to be able to be integrated. And of course, it applies to sale of goods with digital elements. And I picked one item out that we can all relate to, and that is smartphones would be covered under these new regulations. So the warranty part of it, it expands the minimum warranty period from 6 months to 1 year for digital products and services. There's a presumption of defect. That is, if something goes wrong or it's not properly updated and it loses its operational capabilities or other sort of interfaces, then it is presumed to be defective. So the burden of proof is lessened on the consumer or the user of those products. And a material defect, broadly defined to mean failure to provide updates, failure to provide installation instructions, failure to provide information as to the availability and consequences for failure to install the updates. Once again, this all has to be at the cost of the seller or service provider. We have the 2022 EU Digital Market Act. And this generally pertains to the largest platforms to regulate illegal harm, content, and dark patterns. Dark patterns, of course, is a really cool term. It sounds like something from maybe a superhero movie, but dark patterns are really something that have existed since the beginning of time, the manipulation of whatever power information one party has in getting the other party to do things they don't want to do or are not in their best interests. And with AI included and the ability to process large quantities of personal data, this is a real concern. You know, the manipulation in the sort of brick and mortar world is sort of ruthless salespeople trying to sell you an extended warranty for your car, which is a complete waste of your money that should better be placed in a bank and grow it through the stock market or something else instead of paying for a warranty that you'll probably never use and which is about 80% profit to those selling it to you. The problems with AI and big data and big tech is this ability to manipulate to the extreme. It provides a tiered system of diligence, including systemic risk assessments done by the platform. And once again, this is very important. The data has to be accessible by researchers and regulators so we can look into the black box and see where the manipulation is happening. I end up with the German Data Ethics Commission. The shaping the role of new technologies, algorithm-based decision-making, AI, and data. So really, these sort of ethical guidelines are hopefully precursors to hard regulations. They have to be human-centered, value-oriented design of technology. So this is, of course, regulation by design. Risk-adapted regulation, effective oversight of logarithmic systems, aligning digital strategies with sustainability goals, preserving of democratic and social cohesion, and multiple levels of governance. So to tackle this problem, we have to have a new legislation, standardization, technical design, and let's not forget about private law. Contract law, court law, real property law will have to evolve a set of specialized rules, which they are good at least in the common law. It takes a long period of time that we don't have. It's slow to change, but we do know that over the course of the last 100 years, contract law, for example, is disaggregated from a general contract law, which still exists, but more and more of contract or transactions are covered by specialized rules. We don't need to look much farther than traditional things like secured transactions, negotiable instruments, government contract law, employment law. These were all within the general law of contracts, and over the last 100 years, they have developed their own specialized rules. Clearly, contract law, through either legislative intervention or the process of court decisions, will need to evolve specialized regulatory rules for the control of technology, at least as it comes down to consumers.
Larry, don't kill me.
Is that it? I'm done.
No. You're not. You're not done. Relax. Nobody's killing you or taking you off the air. This is not Fox News, so relax. But if you could summarize, because we want to leave some time for Q&A, if that's okay with you.
Yeah, well, I'm done.
You could just summarize. Oh,
I'm
you
done.
Okay? Beautiful. Because thank you. Because
summary right there.
Okay,
I've never come in under time. I'm going to call my mother up after this and say, "Ma,
yeah, I'm a bit surprised."
Shut up for the first time.
No, thank you for this. Very appreciated. Because I just want people to have the opportunity to ask questions. Okay, I have some questions from before. I think this one was in response to Rostam's presentation. Does subliminal AI, I'm editing slightly to save time, does this suggest that AI will tend towards more generalizable, goal-directed systems with more, I like this expression, meaningful control over consumers, which will result in unintended outcomes for the consumers?
Yeah. The answer would be
this is for Rostam, Larry.
Oh yeah,
Sorry, this is for Rostam because we had
very good-looking gentleman, by the way. I can see him very clearly.
And you can pick up from him if you want. Because
maybe Larry can. Yeah. Okay. Anyways, I briefly answer, and then Larry can maybe add something. I just well, that's a very broad question. I'm just afraid that it will not stop. First of all, it already does not stop at consumers. That's the point. I mean, that's what the quote by Dirk Helbing stated, that it's about manipulation in the broadest sense, and that also affects political decisions and all how we act and how we organize society as a whole. So I think we should at this stage be very, very careful and expect the worst, because I think the speed with which these technologies become more and more intrusive, like I said, the Guardian article just a few days ago, mind reading is a reality. So where will we be? And then the question, of course, is what do we mean by meaningful, and who controls what is meaningful? And many more questions.
Effective, meaningful probably means more effective. Larry, what do you think? Consumer manipulation.
I think manipulation, this other side of that coin is abuse. Clearly, we live in that reality right now. You can go on the phone for a half an hour and talk to your best friend about cats and how you love cats, and talk about your fictitious cats. And literally the next day, you'll be targeted with cat advertisements and stuff. So, I mean, it's a scary world we live in. And ultimately, all hands on deck here. The problem is, as was just stated, is the acceleration of technology is so fast. And the manipulation that we now diagnose is probably just the tip of the iceberg. There's probably a lot of other bad things going. I thought it was kind of funny when I saw the owner of Facebook regarding the metaverse and their sort of mission statement. It's all about trusting him. You have to trust us, and I don't really trust them at all. And so, I mean, this is one of the few instances that I can really think in the history of law where, instead of lagging behind social and economic developments, which is always a good thing, right? You don't want the law to jump ahead. You don't want the law to deter, and at least in the capitalist system. But in this regard, we need to jump ahead. And I don't know if we're capable of that from a legislative or private law point of view, but we have to at least shorten the lag. And so, yeah, I mean, the idea of AI and these new technologies, and more importantly, just the proliferation of AI systems and what they do and stuff, and these, marketing, the abuse in marketing and stuff. You go on to buy one thing, ultimately you end up buying three things that you don't need, and probably clearly were manipulated into buying. Yeah, we have to, it's been said over and over again, you can't fight the bear unless you're the bear's size or have some superpowers. And at the end of the day, we have to have smart tech people in government, and we have to have law firms evolve in which they have really good tech people to protect their clients and consumers. I mean, we like to focus on consumers, rightly so, because they're the sort of the greatest amount of asymmetries are found in consumer transactions. But really in business-to-business transactions or large businesses to SMEs, you have the same sort of distortions. And it just gives unscrupulous parties the power that they never had before to manipulate. And they're certainly going to use it as much as they can to grow their businesses. So, yeah, we're in a bit of a bind, and we can only hope that all these initiatives, I mean, there are a lot of initiatives at the international, regional, and country levels, but, it's a global problem, just like climate change, and we're not doing very good with climate change. So we have the same sort of, tensions and problems. And couple that with national policies of being the most competitive to corner the AI market and stuff like that, it doesn't really lead to a lot of transparency. So we're our own worst enemies. And so, as Vladimir once said, the first country to AI controls the world. Scary thought.
Yeah. Yep. Okay. I have more questions. I'm going to just choose this one. I think this is for you, Lutz. It's a long one. Is the logical conclusion to Professor Wolf's talk, where he claims that as an AI can make law, technical and dispassionate decisions, and is therefore superior, we will no longer need lawyers, politicians, parliaments, universities, law professors. Of course, legal decision-making can never be purely technical. It must be contextual and adaptable to changing societal preferences. What do you think, Lutz?
Well, I completely agree, but machines, AI is able to mimic human behavior, is able to assess and access and analyze data and information much faster, much more accurate than human beings. And therefore, those contextual points that need to be considered when enacting law, when enforcing law, are in the better hands when this is done by machines, provided that all those negative aspects that we just heard about, that they can be excluded. And that was my premise, that in fact we are able to deal with all those issues. But machines are certainly more capable than humans to take into account all those contextual aspects. There's a lot of discussion, one more sentence, there's a lot of discussion about whether leniency, whether emotional factors, whether human factors need to be taken into account. No, they don't. Law needs to be technocratic. Law needs to be objective. Those human elements are not needed.
Okay. Any comments from other speakers?
Yeah, I have a comment. Law is highly subjective. The formalist approach that, that human judges and lawyers and stuff only deal with the law, the formal law. And in fact, the formal law is very divergent from operative law, in which emotions and values and equities come into play in almost every case. Even the best UK formalist judge right, will shroud the sort of subjective elements in their decisions and cloak it with pure objectivity. So law is anything but objective. I know I'm sounding like a critical race theorist or something, but at the end of the day, you know, that human element has always been a major part of law, and it's how it's developed. We create exceptions all the time, common law in a slow kind of way, legislative intervention in a quicker way because of these inequities and stuff. So the law is always evolving, and it's basically due to unjust outcomes in cases due to the formal technocratic sort of application of law. So I'm just putting the human element in.
If you allow.
Oh, yeah, you can have as many as you want. You're the boss. You're my boss. You can have 1 hour.
This pretty much sounds like the critical legal studies movement, of course. I take all your points, and I think you're right. In reality, it's like that. But what I'm talking about is the ideal. I'm talking about what the rule of law tries to, what the rule of law actually is. It's an ideal, which is never 100% implemented.
Right. I agree with that.
I wonder whether we have any equity lawyers here. Rost, I'm sorry.
Just one brief, the interesting thing in this respect is only that we see that actually, like I said, AI is a mirror of our own human brain. It's the artificial attempt to replicate and understand it. And interestingly, with algorithms and so on, it's far from being ideal. It makes all the same mistakes that we put into it. So I don't see, unless we become ideal as humans, I don't see any machine getting there before us.
Okay, so I'm going to jump in here and go, AI is maths and stats. Like, it's maths and stats. It's not a human brain, it's maths and stats. Now, there's lots of interesting stuff happening in neuroscience that you talked about mapping brains and understanding how they work. But what we have at the moment are statistical methods, and that's not what humans do. That's precisely what humans are very bad at. And I think that actually the first step to sort of thinking about how we use AI is actually to say, what we've got at the moment is maths and stats, which might be useful for predictions, but that's about all it's doing, and not get sort of carried away with sort of superhuman capacities, because that's precisely what I think leads us down the wrong garden path in terms of regulating it.
Sorry, what was proposing was a thought experiment based on what AI experts say. I cannot claim that we will reach that level. But
I understand that. I understand, and I understand the need to think ahead. But, you know, if we're sort of thinking about what law should be doing in the relationship between law and humans at the moment, then we probably should be actually recognising that AI actually isn't a human brain. It's a statistical model that manages to handle large amounts of data. Now, that capacity is increasing, and I think you're absolutely right that will have all sorts of implications, but it's not a superhuman evil intelligence that we need to control in that way. It's a statistical process that actually beguiles us with its sophistication when it's not actually that sophisticated really, other than in its capacity to handle large amounts of data.
And going back to what Rostam said, so far we have even separate areas of law about bias and discrimination. We left decisions to AIs, and it was discriminating against minorities. And I mean, all the experiments, like, for example, with Compass, with the recidivism prediction, failed. So always privileging white males and always black women got, 10 times the sentence.
But using actuarial processes, which is what Compass is, automating actuarial processes is not new. We've tried to do it again and again, and Elisa, as you say, hasn't necessarily worked. But the problem there is not is not that we don't understand the AI. The problem there is that it's a private provider who's exercising an undue amount of influence on what is a public system with no transparency. Now, those are principles of good governance. Don't outsource public functions to a private provider and then let them get away with, oh, it's commercial in confidence, so we can't see what's being done. I'll stop now. I'll get off my...
Oh, okay. Should we just extend it to midnight and get like extra 8 CPD points? No. Okay, I'm going to stop talking. Thank you very much. I really think we finished on this absolutely amazing high and very controversial note. So I think this is time for Norman to take over. I'm looking at the program and do the final closing remarks. Thank you, everyone, for bearing with me. I'm going to mute myself now officially.